Hello, we are Sovereign from a Superpower, two high schoolers working on an applied civics project for our AP Government and Politics class. Over the past month, we have researched legislation regarding Native Americans in two states, Wisconsin and Nevada. In our research, we focused on how laws regarding Native Americans differed at a state, tribal, and federal level. Specifically, we examined laws regarding marijuana, gambling, and fireworks. I hope you enjoy our presentation of our findings. The United States' involvement with the Native American tribes dates back prior to the official establishment of the nation. Formal recognition of interaction with tribes was first found in the U.S. Constitution. Article 1, Section 8, Clause 3 says, "The Congress shall have power to regulate commerce with foreign nations and among the several states and with the Indian tribes." Due to Article 1, Section 8, Clause 3, Indian tribes are sovereign, meaning that Congress has had the sole right to conduct business and otherwise interact with the tribes. Over the year, the sovereign status of the Indian tribes has been confirmed by numerous agreements, laws, and Supreme Court cases. However, although the tribes are sovereign, they are still somewhat dependent on the U.S. and are protected by the U.S. federal government. As a result of tribe sovereignty, the various tribes within the U.S. retain the right to govern individuals within their designated territory, establishing civil and criminal laws as well as enforcing them. They could create a tribal constitution, which usually mirrors the U.S. Constitution. Overall, the intricate web of political relations between the tribes, states, and federal government is very confusing. Their sovereignty creates many issues, especially clashes of power. For our civics project, we chose to connect our project to the class topic of federalism. Federalism is, quote, "the system of government in which a constitution divides power between a central government and regional governments." That quote is from page 55 of the American Government, Power and Purpose, the 15th edition. This is our core textbook for our AP GoPo class. Effectively, federalism means that the power of a government is split between regions, in our country, states, and the central government. In our country, this is three central branches: executive, legislative, and judicial branches. How does federalism relate to Native Americans? In the U.S., tribes' authority is divided between federal, tribal, and state governments. This three-way tug-of-war for control creates conflicts between the superpower, tribes, and states. Throughout this presentation, we will examine the clashes of power in three areas of the law: marijuana, gambling, and fireworks. Starting with marijuana, at the national level, marijuana possession or usage for any reason is illegal in the U.S. under the 1970 Controlled Substances Act. According to the U.S. DOJ, or Department of Justice, and in cooperation with the DEA, or Drug Enforcement Administration, marijuana is classified as a Schedule I substance, meaning that, quote, "the drug or other substance has a high potential for abuse. The drug or other substance has no currently accepted medical use and treatment in the United States, and there is a lack of accepted safety for the use of the drug or other substance under medical supervision," end quote. Basically, you cannot even use marijuana for medical reasons at the federal level. However, laws differ from state to state, many of which directly conflict with federal law. Every state except for Nebraska and Idaho allow for at least some type of unregulated or regulated medical usage, with 15 states, along with D.C. and some territories, legalizing recreational usage as well. Another nuance in laws regarding marijuana is the fact that while cannabis itself is not legalized federally, some of its components, such as THC, nabilone, and CBD, are legal and some even approved by the FDA. Once again, although marijuana is completely illegal federally, the legalities, the components, and their usages differ from state to state, and because of this, it differs within the tribes of each state. The graph on the screen shows the differences in marijuana legalization throughout the U.S. In Nevada, the first state we examined when comparing state, federal, and tribal laws, marijuana is totally legal for recreational and medical use. However, there are some restrictions. To use marijuana, you must be 21 or over. It can only be sold at a licensed dispensary. You can only smoke it out of private residence, and public smoking is a misdemeanor with a fine of $600. An individual may possess 1 ounce on their person or 1/8 ounce of concentrate. You can only grow your own if you live over 25 miles from a dispensary. Moving on to how these laws affect tribes in Nevada, all tribes have the ability to sell marijuana. However, it's up to the individual tribes to legalize it and make their own rules regarding usage. One conflict with state laws is that on Native American tribes, there is public smoking. There are tasting rooms that are open to the public. In contrast to Nevada, marijuana is only legal for medical usage in Wisconsin. In addition, the THC content of what is used is limited. The condition to which cannabis usage is prescribed must also satisfy a state regulation. A doctor cannot just prescribe medical marijuana for any condition. In Wisconsin, medical marijuana can only be used to treat seizure disorders. While marijuana is illegal in the state of Wisconsin, state and local law enforcement cannot exercise their authority on reservations. However, they can arrest anyone possessing the drug who leaves reservations with it on their person. As far as specific tribes that have legalized marijuana, the Menominee and Ho-Chunk reservations have legalized growth and use of marijuana medically and recreationally. This directly contradicts federal and state laws, demonstrating one way an area that Native American tribes are sovereign from a superpower, or the U.S. government. Moving on to our next section of research, or gambling. Gambling is legal federally, but it's up to the states to decide specific laws. This results in a diverse assortment of laws. In some states, all types of gambling are legal. Wisconsin and other states fall somewhat in the middle as far as restrictions, and in the opposite spectrum, some states, two specifically, Utah and Hawaii, gambling is not legal at all. According to federal law, if tribes want to legalize gambling, they must make a compact between the given tribe and state. This is part of an important piece of legislation regarding to Indian casinos in states, the Indian Regulatory Gaming Act, or the IGRA Act for future reference. There are also important Supreme Court cases. One important one is California versus Cabazon Band of Mission Indians, which reaffirmed the tribe's sovereignty. The graph on the top right corner is showing different breakdowns of revenue throughout the U.S. Starting with the first state, Nevada. Nevada, more specifically Las Vegas, is famous internationally as a gambling destination. There are casinos in Las Vegas, Reno, and also there are many Indian casinos sprinkled throughout the state. Gambling is unique in Nevada because it's central to the economy, and therefore it's legal, completely legal. All types of gamblings are permitted, even sports betting. In Nevada, there's approximately $11 billion in revenue per year from gaming. This is from all the cities, Las Vegas, Reno, other major cities, and various Indian casinos. In Wisconsin, starkly contrasting Nevada, casinos are only on Indian land, but they are a thriving business. The gambling industry and laws pertaining to it are different than Nevada in the sense that the industry in the state began as a result of the Indian Gaming Regulatory Act, in which various tribes had already permitted gambling, so the IGRA Act recognized this fact federally, allowing for tribes in states such as Wisconsin, which do not allow gaming, to enter into a compact, allowing the tribes to have casinos in order to generate revenue. The Indian casinos in Wisconsin generate approximately $847 million in revenue. Now, we can analyze our final area of research, fireworks. In many states, for many people, it's quite common to go to Indian reservations to buy fireworks. However, what are the specific laws? Is this practice really legal? Starting with the big picture or federal point of view, the federal government will set guidelines, some being what's commercial, what's consumer firework, what's an explosive, as well as defining several other legal issues that pertain to fireworks. The Bureau of Alcohol, Tobacco, Firearms, and Explosives is in charge of setting many of these rules. It is a great site to examine the specific rules and guidelines for buying, selling, and using fireworks. Although the federal government will set guidelines, on this particular issue, the states and counties or local governments play a more important role determining the rules and regulations for the usage of fireworks. That being said, in Nevada, the first two states we examined, the laws on fireworks vary in different counties, cities, or